Welcome back, everyone, and thanks for tuning in. I'm Ren with Hive Real Estate Group and Property Management here in Las Vegas, Nevada. And today's episode is a really important one, especially for all of our property owners and the tenants here in Nevada. As many of you guys know, or maybe some of you guys don't know, actually, there were some major changes to Nevada's real estate laws that officially went into effect on October 1st, and that's exactly why we're here today. We're here to get you informed. So these updates affect just about everything: how we advertise rentals, how leases are written, how utilities and application fees are applied and handled, and even how service animals and maintenance responsibilities are defined. Our goal today is to break down what's changed, what hasn't, and how both owners and tenants can stay compliant moving forward. I'm joined by somebody very special, very near and dear to my heart, Demetria Kalfas Gordon with Hive Real Estate Group and Property Management. She is my broker, as well as my mother and my business partner. So Demi's been in the real estate industry for over 20 years. She currently serves as the 2025 Nevada NARPM State Chapter President. She is the current LVR Forms Committee Chair, and she also serves on the Nevada NARPM board as our legislative chair.
Correct.
She's been directly involved in drafting the very forms that every realtor and property manager in Nevada is now required to use. So when it comes to understanding these new laws and contracts, there's truly nobody better to walk us through it. So with that said, maybe, Demi, before we dive into all the new legal updates, can you tell us a little bit about what each of those roles really means? You wear several hats: the Forms Committee, NARPM President, Legislative Chair. How do they all contribute to shaping Nevada real estate? And how have they influenced the way that we run things here at Hive Real Estate Group and Property Management?
There's a correction there. So the LVR Forms Chair is strictly for Southern Nevada, doesn't encompass the entire state of Nevada. But basically, we take a look at all the laws, we take a look at the forms, and make all the necessary adjustments. There's a whole committee that does that. I do happen to be the chair. And as one of the 4 property managers that are on that committee, we were instrumental in putting the new changes in place. And of course, we had attorney reviews to make sure we were all in compliance with the laws, et cetera. As far as the 2024 Nevada NARPM chapter president, I bring this. The NARPM is the National Association of Residential Property Managers.
I think you meant 2025, right? Not 2024.
Oh, yes, I'm sorry, 2025 Nevada NARPM president, I'm sorry. And that basically puts me in...
Just redo that whole sentence real fast. Just start it over. I'll cut it out if he doesn't.
Okay. So as far as the 2025 Nevada NARPM president role, basically we oversee the entire state chapter, and we keep all of our members informed of all the law changes, bring them together to review all the commonalities that we have to ensure that everybody is in compliance and that they know how to proceed moving forward. I have also been the 2024 and 2025 Nevada NARPM legislative chairperson, which in that committee role, we had an attorney that was on there, and we evaluated all the upcoming bills during the legislative session. We put forth some letters to the governor as to our stance. And we partnered with the Nevada Apartment Association to do that, to make sure that we were all in alignment and to try to get some of these. Unfortunately, we were not very successful in making sure AB 121 did not go through. We just didn't have the vote count to be able to go there. And so that was passed, and that's one of the things that we're going to be talking about, the changes today.
That's a really great foundation. Thank you for explaining that, because it really shows how much time and effort has gone into maintaining industry standards before these laws ever really reach the public. So let's start breaking it down, shall we?
Absolutely.
So what's changed as of October 1st, and how does it impact both our owners and our rentals?
Let's start with the lease agreement to begin with.
Okay.
We have to, because of AB 121, what that bill is trying to enforce is transparency, so that when a tenant looks at a rent, say it's $1,000, and I know that's low in today's standards, but let's just use that as an example, and it's $1,000 a month, and they go to apply, and then they find out that this particular property has a pool and has landscaping and trash and sewer, and so now all of a sudden, instead of the $1,000 that may be within their budget, they're now having to pay $1,500 a month when all of that is said and done. So what the legislature has requested is that all in that information be one number called the total fixed periodic rent that's advertised so that people are looking at that. Even though in the past those items were all disclosed, not all property managers had them front and center. And so therefore it confused a lot of tenants, and sometimes they got into leases only to find out later that they couldn't afford the property that they just rented. And so the legislature, wanting to change that, created this, we're on page 1, and also on all advertisement, we have to post that total fixed periodic rent.
Okay, so the term total fixed period rent must appear clearly and correctly for the lease to be enforceable. Is that correct?
Correct. And it must appear on the first page of every lease. It must appear on every advertisement as the total amount, and then it can be broken down in the comments somewhere else. But the total fixed periodic rent must be first and foremost what the tenants or the applicants actually see first.
As well as the utilities. Those must be itemized and disclosed up front as well.
Utilities is a separate issue. Utilities, electric, gas, and water must now always be in the tenant's name, and if they can have it. The only way that we can maintain it in our name, like what we used to do the water bill, we had always maintained it in the owner's name or Hive's name, for instance. And because that's a billable amount that if the tenant doesn't pay, the owner is still responsible for it. So in the past, we were always, we had it connected, and then we would give the tenant a copy of the bill to reimburse. So that way we were always aware that it was being paid. Nowadays, we can't do that. We have to allow the tenant to put it in their name. And as far as the city of North Las Vegas and Henderson, we can still monitor that and make sure that it's being paid as we're going. Las Vegas Valley Water District, though, does not have that ability to do that, so the owner's going to have to call in and double check, and we want to make sure that we do that on a consistent basis. We will remind our owners to do that, but we want to make sure that that's being done, because if the tenant moves out and we don't get a final bill, or the next tenant then goes to apply for the water service and it hasn't been paid by the previous tenant, the owner is still responsible to make that payment. We want to avoid that as much as possible.
So I think one of the main reasons that actually came to fruition is because there were a lot of landlords or property managers, and we are getting a little off track. I want to get back up to our bullet points here to make sure we disclose that. But one of the reasons that this came to be something that was up for discussion even before it became something to pass is there were a lot of landlords, whether intentional or unintentional. They were charging tenants for water, sewer, trash. They were billing them for excessive amounts. You know, you had some people that were not properly disclosing it, and so tenants were stuck footing this random number that they didn't know what that was, and they were not being provided with a bill to reference, right?
And that's the most important part, is they were not being provided with the actual bill to see what they were actually paying for. They were, people were rounding up numbers, they were summarizing, they were adding on top of, which is not allowed. And so this way, it doesn't allow for that, but it also doesn't protect the owner if the tenant does not pay, that's why it's very imperative that we do monthly or quarterly checks to ensure that those bills are constantly being paid.
How are we going to, or how are other property managers and landlords going to enforce that? Are we going to be able to ask tenants for their access codes? Are they going to be required every 3 months to provide us with a copy evidencing that it's been paid? And what is the repercussion if they don't?
Well, it depends on each property manager, how they're going to handle it and how they deal with their contract and their owners. So that's very much a business decision as to how they're going to do that. I can just tell you how Hive is going to do it. For the utilities that will allow us the access, we will call and ensure bi-monthly that those bills have been paid.
Awesome.
Okay. On a quarterly basis, we're going to remind the owner to call in to ensure that the bill has been paid. And for sure, prior to any deposits being released, we're going to verify that those have been paid so that the owner doesn't end up with outstanding amounts.
That's a great system, I think. So one of the biggest issues that we've seen lately, in my opinion, is with self-managed rentals. A lot of owners out there are trying to handle everything themselves, and that's great, but sometimes they're doing it without realizing that they're actually in or out of compliance, right? What are some of the biggest red flags that you notice when you take on a new management agreement, or when a tenant brings us an old lease to review, or if somebody calls you up and says, hey, is this allowed? Because you do get a lot of those calls from
Correct.
owners, property managers, past tenants, future tenants. They know who you are and they want to hear what you have to say, so they come to you for advice. So what would you say one of the biggest issues on the self-managed side of things? What's one of the biggest things that you see that's a red flag?
Well, self-managed owners, they are not familiar with the laws. They don't know all the caveats. And so we'll get stuff like late fees, for instance. They just put in a random number in there instead of the allowable 5% late fee that's allowed. And they can't assess it on the second day. They have to wait the 3 days to go by that the law allows. The other thing we find is excessive eviction fees or excessive maintenance costs without providing invoices to the tenants. There's just a lot of stuff that they are not familiar with the law, because they may have, some of these owners sometimes have 1 to 20 properties and they think that they've got the experience to keep them out of trouble. But what ends up happening is they end up, accidentally, they may be out of trouble for a little bit if everything goes okay. But if there's a hitch somewhere and they get taken to court, then they find out that they owe the tenant a whole bunch of money. And the amount of money that they've saved from having a property manager, a lot of times these owners think that all we do is collect rent and, just keep track, and they don't realize what all we do. But the main thing a property manager is responsible for is to keep an owner out of the liability of getting in trouble.
Yeah, I can't tell you how many times that I've been in court and I've heard the judge tell a tenant or a landlord, mostly the landlord, to be honest with you, that it's not enforceable. Or you don't know how many times that I've specifically had to tell a tenant coming my way or somebody who's called me for information, I'm sorry, but your lease isn't even enforceable, or your lease isn't even valid. Sometimes owners have these, in my opinion, whack agreements that they create. They go to Google and they, pick up a job form and think that they know what they've got going on.
Or currently ChatGPT, and they think
ChatGPT, that's right, but they don't even have a valid lease. And some of these people have been in place for 9 months out of their 1-year term, right?
Or years.
So I can give an example to that too, as we had an owner in the past who we used to do courtesy listings for them, which meant that we would find the tenant and place them. And so we had done that in the past for this particular owner. Went away from it, didn't hear from him for a while. We assumed that, he was going to manage it himself, so therefore that tenant had stayed. But it actually came to be that the term was up and he had decided to rent it back out on his own. And when it came time for us, he wanted to bring us back on. He wanted us to do another lease only for him. And when it came time, we were going to perform the move out walkthrough and then find him a new tenant, place them, and draft the new lease. But he had taken one of our old leases, created his own with a new tenant at that point. But one of the things that he had failed to realize was that the law had changed in 2022 or 2023, July of 2022 or 23. I can't remember. You might know what year it was.
I think it was 23 was the last law change.
In doing that, he had created this lease with this tenant, but he did not receive the appropriate signatures, because if you're doing a self-managed space, you have to have it notarized. And he failed to do that. He also didn't sign himself, which made the lease unenforceable. So we had all kinds of fun things to jump through when we were going through that turn and trying to educate the owners sometimes is more difficult. But my point in saying that is that they do this unintentionally because they're trying to get themselves a great tenant. They're trying to save a buck. But what really could end up happening, and what did happen in this case, was that he ended up owing the tenant thousands of dollars because he was uninformed,
overcharged the tenant utilities and all that other stuff.
Yeah.
And just incorporated a whole bunch of stuff that you can't do.
So before we get too deep in that, and let's kind of get into the current laws that we need to discuss, can you clarify something that a lot of people are confused about right now? Do these new laws apply to every lease right now? When we're talking about scenarios that relate back to self-managed rentals, owner managed, and tenants who are currently in leases, for everything that just went into effect on October 1st. If a tenant was already in a lease prior, would those new laws transfer, or is it only on upcoming lease renewals?
It's only on upcoming lease renewals. So if there's an existing lease that's in place, none of these laws apply. They're grandfathered into the previous. But at any time when the renewal period comes up, again, 60 days prior, they have to get notification, and they have to change the regular rent that was there to the total fixed periodic rent. They have to put in the terms that are necessary that the new leases provide. And in my recommendation, they would be better off drafting a whole new lease with all the new laws already incorporated into it, to ensure that they don't miss anything and become liable.
With that being said, one of the biggest topics that I see blowing up all over social media, all over the news, all over every media outlet that there is right now is geared around application fees and what comes of an application fee if a tenant is not chosen. You hear online, "Oh, I get my application fee back no matter what." Is that true?
No. And this has been further pushed by the media, who interpreted it incorrectly. And so they've put it out there that application fees are refundable. Well, they are refundable only.
And they always have been at broker's discretion, correct?
Yes, but right now the law says specifically that if you have not done anything with that application, you haven't run any credit reports, any background reports, anything like that, then, and you have selected another tenant, then you do need to refund that tenant or that applicant back his application fee. But if you were denied because, like we do, we process multiple applications at the same time, and we're looking for the best tenant for the property. And so we ran your credit, we ran your background check, we checked your previous employers and landlords and all that other stuff. Just because you were denied does not mean you get your application fee back. And that's something that really needs to be clarified out there so that it doesn't avoid a confusion. And part of that is a lot of tenants also do this where they apply to multiple properties thinking that they're going get their application fee back. And so they're not opposed to spending $100 here and there all over the place thinking they're going to get it back. But if those applications are run, they're not going to get those funds back.
Yeah, I think one of the biggest misconceptions there is that we as property managers just collect the fees. And while this law is a good change for tenants, especially for the bad apples that very much were out there doing that, they were collecting applications, not processing, not reviewing, not putting any work, but grabbing that money and going, right? So in that aspect, this law is a very good thing. But for the property managers such as ourselves who actually do review every application, we do accept multiple applications because part of our job is to protect the owner and to find the best qualified and suitable tenant for the property.
Correct.
So the owner, as well as us as property managers, have that right. One of the biggest things is, like, as soon as your application comes in, I do use a third-party system. I pay for your application to be run to begin with. From there, though, there's still a ton of work that has to go in on my side. I still have to manually verify your income. I have to manually contact your employers and verify all that.
Correct.
I have to manually verify your landlord verifications to see if you have substantial residential history. Does my software system somewhat do that? Yes, it does. And are there, maybe there's a better software system out there that does it all for me? Great. We'll look into that. But
It
the
doesn't
fact
matter though,
still
because
remains, you still have to put a personal touch to verify. Fraud is on the rise.
exactly.
AI is a big thing right now. I can't tell you how many on my previous software company that we used to utilize. I'm sorry, I can't tell you how many actually passed through the fraud verification as good checks,
Good
and they
checks.
weren't, and we caught them ourselves. So it takes a lot of time. Sometimes it takes me like 3 to 6 hours to run one application alone, just to verify income, credit, background, and all that good stuff. So
Well, that's
it's
actual
lengthy.
physical time, and then you have to wait for people to respond back as well.
Yeah.
So, when
Yeah,
people
it's a
get
multi-day
frustrated
thing.
when we say it takes 24 to 72 hours to get an application back, they don't understand that it's not just our part that's being done, but we have to wait for responses to come back from other people, landlords, employers, etc., to ensure that we get the information we need. So it's not always dependent on just our time alone.
Yeah, absolutely. And that's what people need to hear. It's really not about punishing tenants.
Oh, absolutely not.
It's about making sure that we're doing our part to ensure that a good tenant is going into the space as well, right?
Correct.
So, okay, let's talk about what happens if you don't follow these rules. What kind of penalties are we looking at?
As far as the application, or
As far as anything, one of the big things in the media right now is stating that if a landlord or property manager does not follow XYZ, that a tenant is able to go into court and file for statutory damages for $250 per violation. So if that's the case, what are we looking at here?
and it's not just the $250. It's in addition to attorney's fees and everything else that it costs the tenant to bring that injunction into play. And basically, if there's any fraudulent activity or deceptive behavior, I guess is the exact terminology that's used, a tenant can actually take a landlord for that.
So some triggers would be like non-outlined lease languages, non-disclosure of fees, mishandling tenant funds, things like that.
Correct, as well as repairs and other stuff. And then in addition to that, you also now have, if you have more than two property or two units at a complex, so if it's a fourplex, duplex, etc., and you do not keep the property in habitable condition, then the tenant can actually take you to court. And if you don't make those repairs, the court can actually take over the property and put the property in a receivership. And then any costs to make the repairs that are necessary, along with putting a tenant into an alternate living space up to 120 days, those are all borne by the landlord with no repercussions. They can't get out of that. And a lot of times
And they have to pay whoever's operating the receivership for them too,
they have to
correct?
pay the receivership, they have to pay the management company who oversees it,
Yep.
they have to pay
That's
the
big money
tenants' accommodations, and they have to pay for all the repair costs. And they're not going out to get estimates like we do for for an owner. They're just whoever they use, they will utilize, and that owner is going to be responsible for all those costs. So although that takes care of a lot of the, there are bad owners out there. And this may need to happen for them because they refuse to make those repairs. And those are the ones that are going to be in a bad place for this. But it also is very important for when we receive a notice from code enforcement for some reason or other, that we act accordingly to ensure that those repairs are done. And hopefully the tenant has come to us first to have taken care of those repairs
Yeah, I was just
before
going
it
to say
even.
that we don't get a lot of code enforcement
No,
calls because
but
we're pretty proactive. But
correct. But in the case where a tenant decides to be funny,
yeah,
okay, and avoid the system and go in there. And of course, if the tenant does that and doesn't provide us with a heads up to make those repairs, we will have that information at court too to
Yep.
fight that battle so that we don't go into receivership, et
yeah,
cetera.
we've seen that done a couple times.
Correct. But what we have to do is make sure that we're proactive to ensure that our owners do not get into that situation. And so we don't get to that point.
My next bullet point was going to be maintenance, but you kind of skipped in there, so that's okay. So let's go back, talking about some of the penalties, some of the things that are required now. One of the other things that I hear most often is, especially when I'm talking to new owners, who are interested in our management services, one of the biggest things that I hear is, well, I don't want pets. So I kind of want to dive into that. I want to share my opinion by telling anybody who's listening, if you are a landlord or a property manager who's not interested in offering the ability to have pets in your home, your duplex, your triplex, whatever it is, you're missing a lot of great tenants, first
Correct.
and foremost. And that's one of the things I also want to highlight for anybody who's listening is that Hive Real Estate Group, we're known as one of the only property management companies who accepts those aggressive breeds, even though by law they're not allowed to deny them now. But
Correct.
we've always been somebody, both Demi and I are pit bull owners and advocates. And so all those pit bulls, huskies, German shepherds, everything that's labeled as aggressive
Right.
by the media or insurance companies, send them our way because we're open to having them. I'd love to pet your dog, so bring him my way. So anyways, with saying that, Demi, what are some of the common misconceptions that we hear regarding service animals or ESAs, and what are the new enforced statutory guidelines around that?
Well, a lot of owners will say, I don't want any pets because I have allergies.
Mm-hmm.
Okay. And although we totally understand the fact that you have allergies, this is a rental property. This
Right.
is your business. And so the intent is that you're not going to live there. I had a recent owner say, well, I'm going to go visit, or when I'm there, I'm going to be allergic. And it's like, you can't do that. That's why you're hiring a property manager. First and foremost, we do the inspections so you don't have to. But at the same time, legally, you can't say to somebody that has a service animal or an emotional support animal that we don't accept pets.
Yeah, they can say it as if they don't want to allow pets normally, but when it comes to service animals and ESAs, there are no restrictions.
There are no restrictions. The HOA can't limit them regardless of weight or anything else. Insurance can't limit them. Nobody can limit them. Now, having said that, there's a lot of people that try to get into properties and claim that they have an ESA or a service animal. And an ESA animal, you can't just go online to some website and pay your $25 and think that you're going to supply that information and it's going to clear.
Very detailed. There's actually a very detailed process that goes into verifying an ESA animal. And a lot of people will tell you, oh, by ADA standards, you're not able to ask these questions. Well, that's correct for a service animal. There's certain questions that you can and cannot ask, but when it comes to an ESA animal, it does have to be a vetted psychiatrist or psychologist.
And we do call those
Right.
professionals
That's what I was
up.
just gonna say.
It has to be on a letterhead. It has to be dated. It has to have their address on it. It has to have contact information so that we can contact them to verify that, in fact, that service animal serves one purpose. So you can't come in and have 6 animals that serve the same purpose.
That's a legality right there. You're actually only allowed 2 animals per ailment.
One animal per ailment. And that has to be a specific ailment. So you can have multiple animals that provide different services,
right.
but you cannot have multiple animals that provide the same service.
One of my favorite things is I've heard, and I'm sorry to go there, maybe some tenants are going to get mad, but that's okay with me. But, I've got my pet unicorn. That's a service animal. So what is an actual ESA animal?
An ESA animal can be anything. A service animal is restricted. Okay, so a service animal can be a dog.
And it is dependent upon your state as well. But
Correct.
For Nevada, let's talk about that.
A miniature or a monkey. Okay.
A monkey.
A monkey, because
know
a
that.
monkey can go to the refrigerator if it's trained correctly and get your medicine.
I watch a ton of monkey videos on social media, so I don't doubt that they could be in.
Yeah, they're very helpful and they can assist people. Dogs, for instance, can sense when somebody's having a diabetic episode.
Yeah, actually.
And alert them that they need to take their medicine. So they have to serve a function like that. Okay?
Yeah.
To be able to be a service animal.
Very cool. We'll hit on that a little bit more in a different session, too. I kind of want to really break that down so people understand without getting too in-depth, but I just want people to be aware because it really is a big topic that I hear when I'm handling leasing and stuff like that. And look, like I said, we're welcome to anything. Demi doesn't like snakes, but I'll go in the properties with snakes. So
Yeah, well,
we allow snakes. You know, I want to talk about that a little bit more, but we'll talk about that in a different section.
let's go back to applications just real quickly. So in the past, some bad actors would take applications for minors. That is also addressed in AB 121, where you cannot take an application or collect an application from anybody that's aged 18 or below.
Oh, I have to tell you a story about this actually real fast. I just had a new tenant, one of our new tenants who just moved in. She was in a bit of trouble, and her prior property manager, a licensed property manager, actually forced her to have her children be added on as financially responsible tenants. They're 5. They're not financially responsible. They
No,
can't
that's
be.
not allowed.
And in the event that she were to have ever gotten evicted or have any challenges if she wasn't able to pay rent on time, that would actually affect those children for the future. And yeah, I couldn't believe what I had seen, that she made the kids sign. This property manager made the kids sign. Obviously the mom signed on their behalf, right? But I had advised her at that point, this is 100% illegal. I cannot
Correct.
believe I'm even seeing this from somebody who does hold a property management permit. But I'm sorry to interrupt you. Go
No,
ahead.
and that's exactly why the law put that into place. So first of all, that you're not, you have a family of 5, you're not paying $500 for an application when 3 of them are under the age of 18.
Yeah.
And then they're not financially responsible. There is no way for them to be. But the new leases now actually have a place where you put the adults on one line, you put the minors on another line, and it specifically prohibits you from being able to charge an application fee for anybody that's a minor.
So it actually differentiates, because before it used to be tenants, leaseholders, and then occupants. So now it actually differentiates.
Absolutely.
Wow.
There's a line on there, so it says total number in the household. So you can put 5 up there. You can put the 2 adults, and then on the separate line, it'll say list the minors, and you want to put the minors in there. And people will ask, why are we listing minors as occupants? Okay, but you have to understand, in cases of an emergency, and I hate to even go here, but in case of a fire, sometimes the fire department will reach out to us and say, how many people are supposed to be in this property?
Yep.
And you say 5. There's 2 adults and 3 kids. And they know it's 2 boys and a girl.
Yeah.
And that's who they go looking for to ensure that they get everybody out.
You actually just hit the nail on the coffin there. I was actually getting ready to bring up our next point too, was another thing that I recognize when we're sending people out for inspections and stuff, is that people have, maybe they're in a roommate situation, or they're with a significant other and it doesn't work out, or what have you. And one person moves out and another person moves in. But they don't notify us. And what people actually fail to know is that that's a lease violation.
Correct.
You are to notify us if
and you have to get permission ahead of time,
you have to get
before that other
time.
person comes in.
Written permission.
Correct. You live in the property by yourself and you get a significant other that you want to move in. That's okay. They just have to apply and be added to the lease.
Yeah, and one thing I want to mention there, that I think people are always scared of that fact. Realistically, if you're already a tenant, nobody's going to tell you no, for the most part. There is cases where we will say no, but if you're already a tenant and you've got somebody else, your scenario just doesn't work out, and now you need somebody else to come in, help split the bill, whatever it is, the majority of the time you're going to get an auto approval. You just need to go through the process in order to do so.
Exactly.
Same thing with pets. If you have a pet passes away, if you, for one reason or another, that pet doesn't fit your household anymore, you get rid of that one. Oh,
an
6
approved
months,
pet that you got permission
Right.
before you moved in.
right? And 6 months later down the road, you say, "Oh, I want to get another pet." We're going to let you have that pet, and the majority of property managers are, but you have to get approval first. You have to pay deposits first, because if you don't, there's hefty fines involved, and you're still going to have to pay that deposit if you want to keep it. But we also, if you go above and against the rules, you might not be offered the opportunity to have that pet remain in the premises at that point.
And then
You're
all of
gonna
a
be
sudden now you have to give up that pet that you
Right.
brought in. But the other
exactly
thing
what I was
that
gonna
people
say.
are not aware of, if you live in an HOA community, especially like in a condo community, they have weight restrictions. They have whatever. So you
Yeah,
got to
that's the
prove
only time that Hive Real Estate Group will tell you can't have a pet is if it doesn't follow the weight restriction for the HOA, by the way.
correct. And because HOAs are very explicit outside of ESAs and service animals,
Right,
of
of
course.
course.
Okay, but if they have a 20-pound limit and they only have 2 animals per property, we have to abide by that. So a lot of tenants, what they don't realize is, say, for instance, like you mentioned, one of the pets passes away and they just go get another pet that maybe is 30 pounds because they're just replacing one animal with the other, but they don't realize that they've exceeded the violations now. So it's always best to ask for permission ahead of time and make sure that that's allowed before you fall in love with an animal. Bring it into your home, and then we're going to tell you you need to find another home for it because we don't want to do that. Pets are a very important part of the family, and we want to make sure that you're able to keep your family members with you.
Yeah, and we advocate for that heavily.
Absolutely.
Even without breed restrictions or everything, we are super super lenient. We want you to keep your pet. You get a fine, you got to pay it, but we are willing to work with you in order to do so because we do not want to see more pets in shelters or, God forbid, being euthanized or anything similar.
Correct.
Yeah, we want them there. We want them with you guys. Okay, so I want to make sure that we have enough time because we did veer off track quite a bit. But I want to get into how the property management agreements. We've talked a lot about how it affects tenants. We have talked about our owners and things of that nature, but I really want to hit on what this is going to mean for maybe our owners specifically or other owners out there who are looking for new property managers to help them with their investments. So let's talk about what changes have been made to the property management agreement specifically. Do you
Okay.
mind?
Nope, not at all, and that's a good point. Remember when we talked about the total fixed periodic rent?
Mm-hmm.
So that is a base rent and then all the other ancillary fees, trash and sewer, your pool, your landscaping, whatever other fees may be in there. So now, in the past, we would get owners that would call up and say, what is your monthly charge? What is my cost if I go with you guys? Well, my response was always, well, let me tell you about our services because it's not always just about that one fee, and the same still applies. But what's even more important now is that you realize that some property management companies out there, and this is strictly a business decision, so some property management companies will charge you now a management fee based on that total fixed periodic rent.
Which is going to be much higher.
Correct. So
Yeah.
even though their management fee may be lower, if they're charging it on a very higher amount, it's still going to be higher than if somebody was to charge you a higher rate and use only the base rent. So
Right.
it's really important that you understand when you're looking for a new property manager what the basis is that they're charging you, along with all their additional fees that they charge that they tack on at the bottom. So you want to get a complete picture and not just ask that one question, what do you charge? You want to make sure all the fees are included and that you understand all the terms. So that way you're comparing apples to apples between property management companies.
So you really do have to interview a property manager when you're getting started now. And if you are, and I've said this from even before the law change went into effect, but I always when I'm prospecting or talking to initial clients, I sell my services, right? That's part of my job, but I also tell them to do their due diligence and make sure that they're interviewing at least 3 to 5 different property managers to see what their services entail because every single one is different. Everybody has something different to offer at a different rate. Some are fully included, some are, additional fees, but yeah, the point is that you really, really need to interview with 3 to 5 different property managers.
And you have to understand the level of service that you're actually looking for.
Yeah.
Because if you just want somebody that just collects the rent, you can go with somebody that offers a very low rate.
5%, yeah.
But if you want somebody that's going to take care of you and make sure that your liability is low and that understands the laws and understands everything, communicates with you and does all that other stuff, you may need to pay just a little bit more because in the end, that's going to save you a lot of money.
Oh, yeah.
And
Just like good labor, good maintenance, You pay for
Exactly.
cheap labor, cheap maintenance, you're going to get shoddy results, and then you're going to have to pay 3 times as much because you're going to have to do it over again.
And the other thing that owners are not aware of nowadays, and even though it's illegal, and property managers can't charge a percentage above invoices for repairs, etc., they still are able to manipulate invoices, etc., to make it appear like they're not charging, but they actually are.
I'm sorry to interrupt you, but that's funny that you said that because I actually had one of our vendors who contacted me and asked me a question. They noticed somebody who was working in a different office who had been with somebody else and had transferred, but that person called them for service and asked the vendor to mark up their invoice X amount so that the property manager, could mark up their invoice even more and collect that fee, and then they would pay him out whatever their original estimate was. And
that's totally illegal.
Totally illegal. And he called and he asked that, and we notified him of that. I actually think you and I had discussed this prior.
Correct.
We notified him that both of those things were illegal, and not only was it illegal, but he also had to factor in the fact that he was going to have to pay for those taxes
on the above
that
on
company.
the increased amount.
Yeah,
Correct.
yeah, crazy.
So it that's where all these other factors come into play. So you really have to know, your property management company and what they're doing. And obviously they're not going to admit that they do that kind of stuff.
Yeah, they're not going to be around for too much longer. So,
well, it depends. A lot of those companies stick around, and then what ends up happening is the law finds out about it. Somebody complains, and then the law gets changed, and then we all have to pay that price, right?
Yeah. I want to say something about, you had mentioned earlier about AB 121 and how we weren't able to advocate strongly enough to have an impact on that vote. But I really want to educate anybody or just make a comment to anybody who's actually listening and say, please, 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 please don't read the headlines. If you are somebody who is actively voting to make a change and you want to see good things come of new laws, make sure that you are reading the fine print. And if you don't understand the way it is being read or interpreted, please ask a professional, because that's exactly what I feel has happened with AB 121, is that there was a lot of people who voted thinking that it was going to be a great thing. And a lot of them are really, really good. But for the ones here, let me back up. One of the things that we haven't really discussed is the cost, right? So everybody who voted for AB 121, it's great. It's going to make sure that everything is outlined right in front of your face nowadays. But what you're not going to understand is how bad it's actually going to impact our industry. And all of those people who, in the past were already struggling to meet that 2.5 times, 3 times threshold, being able to qualify for a property.
Exactly.
They are no longer going to be able, or maybe not no longer going to be able to, but it's going to make it 6 times harder for them now, because now they're going to have to qualify on that higher amount versus
Correct.
the base rent. Before, those other fees, yes, they were inclusive, or included, I should say,
Correct.
because they were additional. They were discussed prior to your lease signing if you were a great property manager. But they were, for the most part, advertised well and included on top, or again, included on top when you were doing your lease signing. But
again, let me correct you there. So there was a lot of bad
probably a
actors, a
little bit.
lot of national companies, etc.
national companies,
A lot of national companies that came in and bought a whole bunch of properties and were leasing them out, and they were not adhering
And
to
some local,
Nevada.
too.
Yeah, and they were not adhering to the Nevada law. So in the front page, they might list a fee as $300, and in the back page somewhere they were listing it as $500.
Yeah.
And so it was very confusing. And these leases were like 70-something pages. I mean, I saw some of them that had like snow removal as part of one of their addendums because they don't adjust it to the Nevada landscape. And they weren't following rules about late fees or any of that other stuff. So what ended up happening is we all got caught up, and the law changed because they were trying to mitigate those companies, but in effect that they made the change to everybody. The other problem with AB 121 is when we have to market that higher rent now. Okay.
Gonna affect comps all the way
It's
around
going to
on the
affect
market.
comps all the way around. They're going to come back and say that we raised the rates, and where in fact we didn't raise the rates.
Yep.
We're still basing it on that $1,000 rental period, but everything else is now added in.
Yeah, one of my
and
rental listings actually just went. It was $2,450. Yes, you did pay for some of the extras, but now because of the new law change,
it's $2,950 if I
20,
remember.
29, 36, 95. Yeah, and my owner for that particular property was actually, or our owner, right? Because we're a portfolio based company.
Yeah.
But they were actually willing to cover some of those costs before, where the tenant wasn't going to be responsible. But now the new law has mandated that if those services are able to be connected in the tenant's name, they are now responsible. So my owner's not paying for
Utilities, solar,
yeah,
etc.
it's
So
all in the
it's
tenant
very,
now.
it's very difficult, and it creates all kinds of other layers.
And especially for those people who are on getting subsidized housing. For those that were receiving subsidized housing or are, they utilize something called the fair market rent versus the regular MLS that we utilize, and they base those rents off their own numbers, whatever HUD provides for that year, whatever HUD determines for that year. And so some of these properties
those numbers are now going to be skewed.
absolutely skewed. A lot of people who have vouchers and stuff like that are not going to, it's going to be much harder for them, which it already was before, but it's going to be 3 times as hard for them to find suitable housing now because the rent reasonables are going to be different.
And on that note, real quick, I want to butt in and say on the, excuse me, on those, any of the housing providers that do subsidize the properties, the tenants must be allowed an animal. That is a new law that went into effect as well. And then now going off of that a second, these laws that come into play a lot of times are nothing more than a couple of people complaining to the legislators.
Yep.
And they make it sound like it's affecting a global amount when it may not be affecting that. And so these legislators think that it's a good idea, and they put these new laws in place. But one of the things that I always say is they don't understand the unintended consequences that comes with these new laws. And we all have to adjust, and we all have to put them in play, but they're not always a good thing. Like if this increased rent, that if they start having an issue with this, and then the next legislative session, they're going to go back and say, oh, now we need to do rent control because our rents have increased so much. But they don't realize that it was a result of this law they just put in play, and it had nothing to do with actual base rents increasing, because in this current market this year, our rental rates, the market has adjusted, and the rates have gone down on their
Quite
own.
a bit. Actually, it's a record breaking how low they've gotten.
Exactly, but it's not going to be reflected, right? Because of this new total periodic rent.
Yep.
It's going to look like the rents have
It's going to look like they skyrocketed instead.
Correct.
When that's not true.
Correct.
What's one of our biggest messages to our owners? What would you say?
Before we go to that, I want to emphasize one more thing for
Okay.
owners to be aware of that's also come into play during this new law is the religious and cultural displays.
Oh yeah, that's important.
In the past, an owner could walk by a property and say, I'm offended by that, or I don't believe in that, and the tenant can't display that. Although that was never really illegal
Right.
to do.
Right.
A lot of owners did that anyway, especially the self-managed owners.
Yep.
Where now it's against the law. A tenant is allowed to display as long as it's not sexually offensive or anything like that, right? Or hate speech or anything along those lines. They're allowed to display whatever they want, both
Good
on
for
the
them.
exterior of the property as well as there's limitations as to size. I mean, they can't go out there and put this huge banner up or anything like that, but there is a limitation, and it's very specific in the law of what that is. And if an owner, say for instance, let's go back to that condo complex we were talking about, and they're now painting the exterior of the buildings, and they're painting the doors, etc., and a tenant has one of these religious or cultural displays on there, they have to be provided 7 days written notice in advance that they will be taken down, they will be protected, and after the work is done within 72 hours, they have to go back up.
Now that's if the tenant themselves don't take it down, right? That's
Correct.
if like the HOA enforces it, or if you're out of town and they take it down. The HOA or the maintenance people are ultimately responsible for your belongings.
Correct,
and
but
have-
that's why they give you a 7-day advance notice, and then if you want to take it down to make sure that nothing happens to it, you're welcome to do that, and then you can put it back up once it's been repainted.
I didn't know that. I know we also wanted to talk about, in regards to self-managed owners, what was allowed for maintenance, because a lot of people like to use handymen. And then the other thing that we wanted to hit a little bit on.
That doesn't go just for self-managed. That goes for even when we manage a property.
Oh, yeah.
A lot of our
absolutely.
owners.
Well, we don't use any handyman. We use licensed contractors to stay in
Correct,
compliance.
but a lot of our owners want us to use handyman.
Like I said earlier, you pay the cheap price before, you're going to pay 3 times later on.
Well, and the law specifically says that the only time a handyman can be used is by an owner in their individual home that they live in. If they have a rental property, an owner cannot use their handyman on that rental property. Again, you have to relate that rental property is a business.
What if they live in a multiplex setting? Can they live in one of the units and have a handyman work on the
Only
other?
on the unit that they live in, not on the other units. They must use licensed contractors. And handyman, they're limited to what they can do anyway.
Yep.
Even in an owner's
$1,000 or
residence.
less, including materials.
That does not apply to any electrical work, any plumbing work,
No special
any
trades.
HVAC, any specialty trades. So you can't come in and use a handyman to put up your ceiling fan
And if
or
you
to
have,
fix your faucet.
and
Or
if you utilize any sort of subsidized housing, they can't touch drywall or anything either if it's a property that has asbestos or lead possibilities.
correct.
Yeah.
Well, they can't touch that stuff anyway.
I
no
know,
matter
but
what.
we're talking about handymen here, so they
Yeah.
will, right? They can do everything. They're supermen.
Yeah, they're masters of
all
everything.
trades,
Jack of all
master of
trades,
none.
master of none.
Yeah.
Right, is the way that saying goes. And then anything, as far as repairs are concerned as well, anything that's habitable, anything that has to do with any system, electrical, plumbing, HVAC, door locks.
Yep.
Okay, any of those things, they have to be repaired, or they have to be dispatched within 48 hours from the time that a tenant submits it. And you can't back charge that tenant for any of those costs unless that tenant specifically did the damage themselves.
And you have to be able to prove that.
And you have to be able to
Yeah.
prove that. It's one thing, sometimes we have a sincere suspicion, but if we have no way to prove it, we can't charge them for it.
You actually have, and I might put somebody on blast here, but I won't say their name, but I actually saw one of our peers who we've kind of tried to, they are a property management professional. They're newer, but I've heard you in numerous settings try to educate them about the right thing to do. I was actually in one of the little property management Facebook groups that I play around in the other day, and I had seen a post by this individual asking about, there was water damage to one of their units. It was a 3-bedroom, 2.5-bath home. There was 2 showers in the property. There was clearly, they provided a photo. There was clearly a construction defect when they built the home because of the way the tile separated. You could see that they did not use the correct red board behind it. They probably didn't use the proper materials to seat it either when seating the tile and grout. And so those tiles just completely shifted apart. There was a big old space. And
Of course, water got in there.
And water got in there, and the property manager that I'm referring to tried to charge the tenant for it. And there was probably a good 200 comments on this post. And every single person, yourself included, you're in that group, came down and said, I'm sorry, but you are wrong. This is not the tenant's fault. And that property manager kept saying, yes, it is, because if that tenant it happened within a week, they notified him within a week. And he said, if they had notified me on day 1, this wouldn't have happened. It's evident by
That is true.
common eye.
We ask that the tenants notify us within 24 hours for any water intrusion.
Sure.
But if it's a constructive defect to begin with and there was
could see
nothing
that it
that they
was.
couldn't have done, then there's no way you could charge the
Yeah,
tenant.
you could see that this wasn't something that built up, that the tenant was monitoring, wasn't aware of. Yada, you could see it was a clear crack. Yes, maybe they went a little bit too long without properly notifying their property manager, but the fact remains the same, is that it was a defect. and it is a landlord responsibility. But my point in saying that was about, actually, I forgot my point, but it's somewhere along the lines of education and
Did they
doing
try
the
to
right
use a
thing.
handyman too to fix it?
I'm sure that they did, knowing this individual. Yeah.
Okay, that's what your point was. You can't use a handyman for those
Yeah.
kind of repairs because
No, actually, my point was geared towards charging. We were
oh,
talking about that, and they were trying to charge the tenant, and we were stating that inhabitability matters and essential services and things of that nature, or
can't charge a
defects like that, that you can never charge a tenant for that.
Correct.
It's not the right thing to do. I
Correct.
think that's one of the things that we should focus on, maybe not educating, but saying more often to our peers, is that what is the right thing to do, what is the lawful thing to do, because that's the bottom line here in property management.
Unfortunately, you can educate people, but then it's still a business and you can't make them do that. They have to follow the law of their own behalf. Whether they do or they don't is up to them at that point.
Well, that's why I'm really lucky that I have a really great broker who's very well informed on current legislature and any upcoming, provides me with a ton of resources, forces me to go to classes that I don't always want to go to.
Knowledge is power.
I believe that 100%.
And our job is to protect our owner. So the more we know, the more we can protect them.
Yeah. So what do you think? I know that we've got to run because we're getting close to our closing, and you have another appointment with the Forms Committee, by the way.
Yep.
One of the things that I want to put out as a message, if you're a realtor or another property manager or salesperson, leasing agent, whatever you are, and you're listening to us, one of the messages that I want to share is that if you have a client or an owner, but let's talk about salespeople. If you have a client that's searching for their next rental investment and you do not do property management, but you are showing them property, whether it be for short-term, mid-term, long-term, unfurnished, whatever it is, please reach out if you have any questions. A lot of our owners one of the things that we do at Hive Real Estate Group is we do long-term unfurnished properties. We do a lot of short-term and mid-term rentals with the proper licensing for short-term. But we do corporate fully furnished vacation rentals, and a lot of the things that we see from owners that we gather as new management clients is that their realtor, when purchasing a property, their realtor advised them that this was going to be a great property for short-term licensing, but that realtor was not educated on the laws and what type of licensing is required for short-term rentals, especially in
And what ended up
Henderson
happening
and
in
Clark
that
County.
is the owner gets really frustrated with their realtor because they were very specific with them that this was what they wanted to do. And then come to find out after they spend all these hundreds of thousands of dollars that they now can't do that. And when they
so they're
come
out of
to
client. So
Yep.
one of the things I wanted to say in that is that if you're a realtor working with your client to find something like short-term housing, or if you've got somebody who's looking at investing in multiplex properties or anything similar, we are happy to help advise you along the way
during the sales
during the
process.
sales process,
Yep.
just to be friendly, especially if it's somebody who may end up in our path down the road as a management client. I'd rather lead them in the right path to begin with than have to veer through the traffic cones because they've been.
And we want to make you look good too. We
Yeah.
want to make sure that you are advising your client on the proper property to purchase. And we'll go to inspections with you. We'll do all of that stuff. We'll run rental comps for you and tell you what is actually what we feel you were going to be able to get so you could advise your client and make you look like the $1 million star that you are. And then if you do refer that client to us, then we do pay a referral fee. And we
if
make
they want to
sure
sell in the future, or if they want to
Yep.
purchase another property, they're your client. We'll
Right.
take them for management. We do sales as well. We
Right.
do sell, buy, and purchase investment properties for owners or first-time home buyers or whoever. But if you are a realtor who's bringing us a client, you can have them back. They'll stay with us for management. You get them on the sales. We honor that.
Absolutely. We honor that
Integrity is
relationship.
really, really big for us.
Absolutely. Absolutely. And like I said, we want to help you along the way. We want to make you look good. Because if you look good, your client likes you, that we make money for them in the property management arena, and then you get them back to buy another investment property and another investment property from there. And we work together as a team, and that's always a win-win situation.
So let's kind of close this up a little bit. I want to review a couple of my notes if you don't mind. If you
Yep.
want to think, do you have anything else that you want to share? I think one of the biggest takeaways for me in this session would be to discuss that real estate laws are about structure, right? They're about structure, they're about transparency, and that's always been the case, but now more than ever, if you find yourself, if you're an owner specifically, and you find yourself in the courts for any reason, whether it be eviction or habitability or anything like that, the old saying of, oh, I didn't know isn't going to work. The courts are not going to take it anymore. They don't care. You're going to be liable for it. You're going to owe. Maybe you won't. Maybe you'll do the right thing. But be educated. Get informed. Call us if you have questions. Call Demi. She's got way more knowledge in her brain than I do. But, yeah. Let us know what you need. We're Hive Real Estate Group. Do you have anything else to say? I'm sorry.
Yeah, and for those self-managed owners, we're here for you as well. We're here to answer questions to make sure you're doing the right thing. We don't want people getting in trouble.
No.
And you're right. The courts are not going to take the I don't know, I didn't know that as an attitude, because ignorance is not bliss in this particular situation. So give us a call and we'll get you updated on what you need to know to continue to self-manage, or at some point in time, if you want us to manage your property, we'd be glad to do that as well.
We're a Hive Real Estate Group and Property Management, Las Vegas, Nevada. Our office is located downtown in Lawyer Row, just off of 7th and Clark.
Yep,
And
520 South 7th Street to be exact.
That's right. We are a full-service real estate brokerage doing all aspects of real estate, sales, property management, you name it, asset management. And the type of properties that we do manage is multiplex properties, single-family homes, lots of single-family homes.
Condos,
short-term
townhouses, short-term,
midterm rentals, corporate
long-term.
vacation rentals, all that good stuff,
Yep.
long-term unfurnished. So if you're somebody who's looking to rent, give me a call, 702-518-2332. If you're somebody who's looking to invest, sell your property, purchase a property, whether a first-time home buyer or a seasoned investor, Demi's your lady, 702-839-2798. Yeah, give us a call. Let us know how we can help.
Yep. And real estate agents, like we said before, if you've got questions and you don't understand something, please call.
And we do pay referral fees.
Yep. All right.
Thanks
Have
so
a
much.
good one.